Everybody, I'd like to call this meeting to order. Welcome to meeting number 22 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to begin a study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence, delays, and other measures. Excuse me. Today's meeting is taking place in hybrid format. Pursuant to the standing orders, members are attending in person in the room and on Zoom. Can we confirm the sound tests were all done?
Yes.
Yes, okay, great. A few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, at the bottom of your screen, you can see the selection, the appropriate channel for interpretation, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Reminder that all comments should be addressed through the chair. For members on Zoom, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding. So now I would like to welcome two of our witnesses. We have from the Suggest Domestic Violence Prevention Society, Andrea Silverstone, who's the Chief Executive Officer, who's on Zoom. And from the Women's Legal Education and Action Fund, we have Roselle Kim, who's the Senior Staff Lawyer. We will be joined soon, hopefully, as an individual by Allison Irons. But we will get underway with the two witnesses we have. First of all, welcome to both of you. Can you hear me okay?
Yes,
okay.
Thank you.
Okay, great. Thank you. So I'm going to open the floor. Each of you will have up to 5 minutes each to do opening remarks. And then following the conclusion of all opening remarks, we will go to questions. Hopefully by the time the two of you have completed your opening remarks, Ms. Irons will be with us. If she joins, I may interrupt in between one or both of you just to welcome her. So I will open the floor, and I'll just go by first person on my list, which would be you, Ms. Silverstone. So welcome. You have up to 5 minutes.
Thank you so much. Good afternoon. My name is Andrea Silverstone. I am the CEO of Suggest Domestic Violence Prevention Society, an agency that works to disrupt the structures of abuse with individuals, organizations, and communities across the provinces of Saskatchewan and Alberta. Thank you very much for the opportunity to appear today before this committee to discuss Bill C-16. There are many aspects to the bill, all of which are important. However, today I'm specifically going to address coercive control in the context of criminal legislation. My background in understanding this issue comes from over 20 years as a social worker, working with victims of coercive control, and as a PhD candidate studying the trans-contextual experiences impacts for victims. Suggest strongly supports Bill C-16's recognition of coercive or controlling conduct as a distinct harm within Canada's criminal justice framework and its inclusion in the femicide legislation. Based on my PhD research, I understand coercive control to be a pattern of behavior that removes an individual's sense of personal agency, stopping them from making decisions in their own best interest. Coercive control is trans-contextual. It appears in intimate partner relationships, sexual exploitation and trafficking, cultic groups, gangs, elder abuse, radicalization and violent extremism, workplaces, and even via institutional misuse. Survivors often traverse multiple contexts across the lifespan with harms that compound over time. Criminal law must adapt to meet this reality. Traditional incident-based offenses miss the pattern and impact dynamics that define coercive control. The criminalization of coercive control is more than just about lethality. It's a liberty crime. Comparative models in other jurisdictions criminalize patterns that cause a serious effect, such as substantial interference in which day-to-day activities occur. Bill C-16 allows Canada to adapt these strengths from other jurisdictions while ensuring cultural safety and charter compliance. However, in my opinion, there continue to be some challenges and limitations that I think need to be addressed. First, the narrow relationship scope of this bill may lead to an undercapture of coercion in relationships of dependency and trust. For example, caregiving relationships or sexual exploitation. Secondly, the proof burden risks reverting to incident counting unless pattern and impact elements and illustrative factors are explicit. And lastly, it does not adequately address institutional misuse, especially in civil settings. And by this, I mean things such as procedural harassment and vexatious applications. These acts are persistent vectors of harm and coercive control that require legislative implementation guidance to both flag and manage the weaponization of systems and institutions by perpetrators. I also want to briefly address concerns that have been raised around this legislation regarding equity impacts and overcriminalization. The best available evidence from jurisdictions with coercive control offenses do not show widespread criminalization of minority victims. I address this in more detail in my submitted brief, referencing numerous studies, all of which clearly identify that perceived risks to equity and overcriminalization have not materialized. I would also like to suggest the following recommendations to this legislation to ensure that it truly captures the experiences of victims. Firstly, please update the legislative wording to reference relationships of dependency and trust. Second, codify that the offense includes patterns that cause either serious alarm or distress that substantially affect day-to-day activities. Third, provide a list to guide the justice system to reduce over-reliance on physical markers. Fourth, include an interpretive note acknowledging that coercive control is trans-contextual and may occur across the lifespan and in multiple domains. Coercive control clearly occurs in more than just IPV relationships. Fifth, in regards to evidentiary guidance, encourage pattern chronologies, digital trails, collateral testimony, and explicitly allow expert evidence on the impact on the victim. And lastly, provide safeguards against institutional misuse, requesting federal provincial policy to flag procedural stalking and paper abuse. Legislation is the starting point for change, but for it to be truly effective, federal investment is required. I believe there are three key investments that would support the success of this legislation. They are validated survivor impact measurement tools, which currently don't exist and would need to be developed, training for the justice system and service providers around coercive control, and investment in a national public education campaign and initiatives that engage community and informal supports in addressing coercive control. I'd like to thank the government for tabling this important legislation and thank this committee for your time and consideration of care in ensuring that Canada is a country that protects victims from coercive control.
Thank you, Ms. Silverstone. Right on time. Over to you, Ms. Kim.
Thank you. Good afternoon. My name is Roselle Kim. I'm a senior staff lawyer at the Women's Legal Education Action Fund, or LEAF. LEAF is a national charitable organization that uses the law to advocate for the equality of women, girls, trans, and non-binary people. Thank you for inviting me today to speak up Bill C-16. My remarks today are based on the written brief that was submitted to the committee jointly by LEAF and the Barbara Schleifer Commemorative Clinic. Of course, I'm here today to speak for LEAF. We welcome and support the bill's proposal to increase access to testimonial supports for victims and witnesses. The rigid rules and decorum of a courtroom can lead to additional stress and trauma for survivors who are revisiting and disclosing traumatic memories. In addition, we support the bill's increased emphasis on restorative justice processes, though we make one suggestion in our brief to ensure what a survivor discloses during the processes are not used against them in future proceedings. We also agree with expanding the non-consensual distribution of intimate images offense to include deepfakes. We are grateful for the efforts of parliamentarians to respond to the epidemic of gender-based violence. We understand the intent behind using criminal law reform to tackle issues like femicide and coercive control as a public recognition that these acts are serious and wrong. However, well-intentioned laws can have unintended consequences. As such, we express caution towards the amendments in the bill concerning femicide and coercive control. While we agree with the need to recognize and address these issues, creating new criminal offenses without clear survivor-centered safeguards could lead to survivors being caught up in the criminal system and charged themselves, especially if they're members of marginalized communities. We believe a broader systemic approach is a better answer to preventing and addressing gender-based violence. There are, however, ways to improve the criminal responses to gender-based violence, and I want to highlight 5 areas where we have suggested amendments to the bill in our brief. First, I'll discuss mandatory minimum sentences. Mandatory minimums do not deter crime and have negative impacts that are specifically detrimental for Black and Indigenous communities. In addition, imposing prison sentences on Black and Indigenous women who are mothers or caregivers of children can lead to disastrous consequences for the women, the children, and their communities.
Thank you.
Including family ruptures and overrepresentation of Black and Indigenous children in the foster care system. For these reasons, we recommend broadening the exceptions or safety valves to mandatory minimums, applying a gender-based analysis, and not reintroducing mandatory minimums that have already been struck down. Second, we proposed a series of amendments to the sections on sexual history evidence and third-party records. While we appreciate the desire to clarify this complex area of the law and reduce delays, we have heard concerns from lawyers who work with complainants about the risks of increased complexity and constitutional vulnerability in the bill. We also point to a change needed in the process to ensure that the complainant's intimate images are not shared between lawyers. I'm happy to discuss specifics during the question and answer period. Third, we recommend maintaining the current wording of the criminal harassment provision. The proposed changes in the bill may increase the risk of survivors being charged with criminal harassment themselves in situations where survivors have to make repeated contact with their abusers about failures to respect custody arrangements or other court orders. Fourth, we recommend broadening the definition of deepfakes to ensure that it appropriately captures the harm caused by non-consensual deepfakes. The definition of a deepfake in the bill requires that it is likely to be mistaken for a visual recording of that person. However, the harm of non-consensual deepfakes goes beyond deception. It is a violation of sexual integrity where your image is sexualized without your consent, even in a manner that may not meet the realism threshold. Requiring realism for deepfake to be criminal defines the harm of deepfakes too narrowly. It also adds confusion about who will determine whether a deepfake is likely to be mistaken as an actual visual recording. For this reason, we recommend removing the last part of this definition. Lastly, we recommend that the federal government work with provinces and territories to decrease delays in the criminal legal system, rather than requiring courts to rely on remedies other than stays. Meaningful reduction in delay requires adequate resources, including increased staffing, judicial appointments, and stronger governmental coordination to ensure the system is properly supported. I'll end by reiterating the need for sustained investment in preventative measures that address gender-based violence before it occurs, including community-based supports, education, and early intervention initiatives. Criminal law alone cannot end gender-based violence. Thank you very much, and I look forward to answering any questions.
Thank you, Ms. Kim. And I'd also like to welcome now Allison Irons. Can you hear me, Ms. Irons?
Yes, I can, Chair. Thank you.
Okay, well, thank you for joining us. Your sound check is okay?
Mm-hmm.
Can you just say a few words so we can just do a quick sound check on your microphone?
I will actually, before I start my remarks, I'd like to let the committee know that I have an autoimmune disorder that affects sometimes my speaking ability because my mouth gets very, very dry. So I may have to take a few sips of water while I'm speaking.
That's fine. Thank you. Your sound is excellent. So we're just at the opening comments portion. Our other two witnesses just finished theirs. So I'm going to give the floor over to you. And you have up to 5 minutes to make opening remarks. And then following that, we're going to open the floor to questions, which can be put to all three of you. So I will give the floor to you now, Ms. Irons, for up to 5 minutes.
Thank you. Good afternoon, everyone. I'd like to thank you for inviting me to speak today. I'm an ex-RCMP officer of 9 years service who attended many so-called domestic disputes during that time. I was also on the board of the North Shore Women's Centre in North Vancouver, BC, as a police advisor on violence against women. That was some 40 years ago, yet here we still are today. I also worked as an Ombudsman Ontario investigator and investigations manager, particularly in the corrections field. I retired as a Director of Enterprise-Wide Services in Ontario Government, and I'm certified as a Canadian Human Resource Leader, or CHRL. Sadly, I'm also the mother of 26-year-old Lindsay Margaret Wilson, born July 30th, 1986, my precious daughter and best friend, who was stalked and shot to death by her ex-intimate partner, a legal gun owner, in a murder-suicide on April 5th, 2013 in Bracebridge, Ontario, just 2 weeks before completing her Nipissing University graduating exams. I received her degree posthumously and drove home from North Bay with a degree, but no graduate. This is a story of coercive control ending in a femicide in Canada. My daughter's killer had never been violent with her until the day he murdered her in cold blood. He was clean-cut, articulate, and from a well-to-do family. He was also manipulative, deceptive, and controlling with my daughter in a number of ways. He'd say she was the love of his life, but would undermine her self-confidence by constantly criticizing her looks, her career choice, and clothing choices, etc. She left the relationship the first time when she caught him drug dealing behind her back. That was another manipulation, a massive lie, as he was not who he purported to be. He lured her back with manipulative letters articulating his love for her, apologies, and the inevitable promises of changed behavior. 3 times, he threatened suicide by firearm to keep her with him. Excuse me. She kept 2 of these from me initially, as she knew how I'd react. We must understand that threats of suicide to keep someone in a relationship are a form of coercive control, since they terrify the recipient of the threats into staying. She then caught him drug dealing again and broke off the relationship for good in 2011. In January 2012, he threatened to commit suicide by firearm over 3 hours on the phone with her. She then severed all contact with him, but he kept trying to contact her through blocked phone calls, friends, social media, and letters, professing undying love, saying it was all his fault, but still undermining her self-esteem. He continued to bring up a phone bill, an old debt he contended she owed when she insisted she did not. I even offered to pay it for her to get him off her back. My daughter, a principled person, refused to let me. By this time, I was counseling her on how to diffuse and get out of the situation. She was terrified of contacting the police due to fear of reprisal. I even offered to send her out of the country or province to university for a master's degree if she wished. But she still felt love for him and never imagined for a moment that he would do her any harm, despite my warning of the risk with the presence of firearms in his house. The police later told me he would have found her wherever I had moved her, given the plan they'd confirmed he had. The week of her murder, he drove 5 hours to Bracebridge and found her car in the university parking lot. He stalked her and then found out where she was living. He went back that Friday, stalked her all morning, then hid behind the house and confronted her with a shotgun in the driveway as she was packing to come home for the weekend. While she pled for her life, he shot her with both pellets and slugs at close range, sent her body mass, an obviously fatal injury, and what the Central Regional Director of Crown Law called a clear case of first-degree murder. She survived for only about 20 minutes. She told paramedics she knew she was dying, a horrifying thing for a mother to live with. My daughter's planned and deliberate first-degree murder caused me to lobby for a criminal coercive control offense since I learned England, Wales, and Scotland had done that, and also for more first-degree murder charges to be laid in cases of femicide. I've monitored how coercive control cases are going in the UK justice system. Initially, although police were laying charges, only 50% were successful.
Ms. Irons, I'm going to have to ask you to wrap up, please.
Okay. The education of the criminal justice system regarding coercive control is an absolute necessity before implementation of this bill, as was done in Kyra's law. Abused women are at greater risk of harm or fatality if such charges fail in court because the justice system doesn't understand nonviolent coercive control as a stepping stone to eventual violence. I firmly believe, as an ex-police officer, that a conviction for coercive control on one's criminal history will serve as an evidentiary building block to corroborate any future pattern of behavior that might progress to violence or worse, femicide, with first-degree murder charges able to be laid.
Thank you. Thank you. Okay, I'm going to turn it over to Mr. Gill, I believe, to start the first 6-minute round.
So thank you, Chair, and good afternoon, everyone. Thanks to all witnesses for coming here. My question to Ms. Silverstone, you have indicated in your brief it is a step forward. This bill is a step forward, and there is a room for improvement in this bill. Do you feel that this bill properly integrates the Status of Women's Committee's November 2025 recommendation on coercive control?
So the answer is I believe that it properly integrates those recommendations. And I also think that it needs to be broader in that it needs to look at relationships of dependency and trust, not just intimate partner violence. I also would suggest that some of the things that did come up were around equity and overcriminalization. And I understand those concerns. However, the research that is out there that has come from the UK, England, Wales, and Scotland has said that there is no overcriminalization that has happened, nor have equity-seeking groups been more affected than they already were by a justice system that obviously has its own limitations. But that's not about coercive control. That's about a justice system response generally.
Yeah, I understand you have said that it has to be more broadened. That would be more impactful, I guess. So what would you recommend to amend in this bill to better reflect those recommendations, if you have any?
So in particular, that is in my brief, but I think that the relationship that should be identified should be a relationship not of intimate partner, but a relationship of dependency and trust.
And regarding coercive control, your organization said that criminalization alone is not enough. Training, education, and survivor supports must come alongside it. Bill C-16 criminalizes it, but has the government given any indication they intend to pursue the other things you called for?
So the answer is, to the best of my knowledge, not at this time, but in my conversations with government, they are aware that part of what does need to be in place are measurement tools that don't currently exist, that do need to be developed, that there is going to be a necessity to train the justice system and service providers. And I would also suggest that the government recognizes that we need to change the discourse in Canada, but I haven't heard a distinct statement of, and if we pass this bill, these funds or these initiatives will come along with it. But I also haven't heard them say they don't think it's important. They've said that they think it's important.
Did the government consult with your organization while drafting this bill?
They did. We are actually the organization that helped to draft the two previous iterations of the bill. The first one was a private member's bill from the NDP, from Randall Garrison, and the second was a private member's bill. And we were instrumental in supporting the drafting of both of those. And we also had input into the drafting of this, which is based off of the language in both of those and the report, I think, of this committee around the shadow pandemic.
You just have indicated that there are certain measures that you got assurance to be added but not added yet. Does this bill reflect the advice given during those consultations?
Sorry, can you ask that question again?
So my straight question to you regarding the recommendations or suggestions you have provided, does this bill reflect the advice given during those consultations?
I believe that the bill reflects in part the advice given. I think that I understand that there are limitations in how bills are written and that there's a desire for them to be able to move forward. I'm not a legislator. I'm not a lawmaker. I'm a social worker. I know what's best for the clients that I work with. And so it's very possible that the things that we're asking for are not maybe possible things exactly within a legislative framework, but that is for greater minds than mine. But I do feel like the big thing that is missing right now is that it has to be broader than just intimate partner violence. I actually also wrote a position paper that went to the Federal Ombudsman of Victims of Crime, specifically around sexual exploitation and trafficking. If we leave out that population, we're going to be doing a whole group of people, women, an injustice by not protecting them with this law.
Thank you, Ms. Silverstone. Ms. Kim, my next question to you. I was reading your organization's submission on Bill C-16, and I see you raised issues with the government's proposed changes on defects. My colleague Michelle Rampel Garner also has a bill before this Parliament on that subject. The bill is C-216, an act to enact the Protection of Minors in the Digital Age Act. Are you familiar with this bill?
I'm not very familiar, but I know of the bill, yes.
So do you have anything to say that which bill would be, you say, does the better job, or there is no knowledge about 216?
I want to focus my comments on C-16, which is what my brief is about. So And, like I said, we welcome the inclusion of deepfakes, but we did suggest the one amendment to make sure that all the harms of deepfakes are captured.
And is criminalizing coercive control enough to help victims and survivors?
In our opinion, we do not think that creating a new offense of coercive control gets to the root causes of coercive control. And we also have some questions about how evidentiary collection would work and how certain victims may be perceived, especially if they are Indigenous and Black women who often are labeled as more aggressive or perceived as more aggressive. And so for that reason, we make recommendations about taking a proactive approach on focusing on prevention and providing mandatory and ongoing training to law enforcement, crowns, and judges on what coercive control actually looks like, as well as systemic bias, so that can be recognized.
Thank you. Thank you, Mr. Gill. Ms. Dillon, over to you for 6 minutes.
Thank you, Mr. Chair, and thank you to all three of our witnesses who are present here today for your dedication and long time work on this very important issue. I will start with Mrs. Irons. We're very sorry, the whole committee, for the tragedy you have experienced, and to have come here today and testify in such detail to a painful and deeply disturbing event in your life. We thank you for your courage for that as well. And I would like to start, first of all, with you have advocated your whole life for recognizing the importance of patterns of coercive control and these kinds of behaviors in intimate partner violence. What are your thoughts on the part of the bill that would require a first-degree murder charge in case of femicide, where a pattern of abusive, harassing, coercive, or violent behavior can be demonstrated to the court?
Thank you for the question. I feel very strongly about this, and some of it is, I must admit, to perception. But we who work in this field, whether professionally or as an advocate like I am, far too often see second-degree murder charges laid in cases of femicide. Often that's because it's well known in the justice system, and as an ex-police officer, I can tell you, it's an easy guilty plea. It saves the courts and the justice system a lot of time and money, but it also results in bail. It results in lesser sentences. It involves earlier release. And with all of those things comes a higher risk of recidivism. And it's very, very hard as a female, and I can tell you my first marriage itself was an abusive and coercive one. It's very hard to believe sometimes that it's not just simply the sexism which exists within the system that says, if a man says, oh, I lost control, or she made me do it, or she provoked me, that isn't accepted, and that results in the second-degree murder charges. Experts in the field will tell you that a man who's abusing or harming a woman is usually very much in control. And that's sometimes why women's injuries are in places that can't be seen when they're clothed. So I feel very strongly, and I think the bill gets at this, because the question is the evidence to support a first-degree murder charge. And what the bill says, or what this clause says, is that providing a pattern of harassing, abusive, violent, or coercive control behavior can be demonstrated. And I think that helps immensely get us to more first-degree murder charges in case of femicide. Otherwise, the disproportionate laying of second-degree murder charges in cases of femicide, I view as discriminatory towards women.
And do you believe if this had existed at the moment where the tragedy occurred for your daughter, the accused would have had a tougher sentence?
Absolutely. He would have gone to jail. He didn't. My daughter was terrified of calling the police. She was actually afraid the police would take his guns away and that would tip him over the edge into violence. It was a very hard discussion I had with my daughter about whether to call the police or not. I also knew at the time from being a police officer that if we tried to get a restraining order against him, the service of the restraining order on him might be the very thing that tipped him over the edge into violence, which is why I've also worked on the Bill C-21 provision for protection orders and the removal and seizure of gun licenses and guns.
And you spoke about manipulation. What signs of manipulation can you quickly tell us that it would look like somebody's being victimized?
Financial is one. A very good friend of my daughter's I had to help after my daughter's death. She had a new boyfriend who seemed very nice and so forth and well employed at first, and then gradually began to control all her movements, began to demand to check her phone, would follow her, would call her at several times a day to find out where she was, when she was going to be coming home. In the case of my daughter, that phone bill that I mentioned, it may seem like a minor thing, but he never let up on that phone bill with my daughter. And even until 3 weeks before she died, he was still bringing up that phone bill that she said she did not owe that money. So there's a form of debt that is alleged to be owed that can also be held over a woman's head. Gaslighting is another form. I was told by my ex-husband that if I left him, nobody would ever love me enough to want to marry me again, for example. So these things are all intended to keep you under their thumb so they know where you are all the time. You get isolated from your friends and family, partly because you're embarrassed. And then there becomes the question of how to leave, which, as we all know, is a very dangerous time. And I'm so proud of my daughter for having had the courage to leave.
Thank you.
Thank you, Ms. Dillon. Mr. Fortin, to you for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to our three witnesses for joining us today. I'll begin with Ms. Silverstone. First, I'll offer my most sincere condolences to Ms. Irons for the events she described to us. No one should go through what you did, and my heart is with you. Now, Ms. Silverstone, the question of coercive control, we've talked a lot about it in couple relationships. That makes sense. This is a scourge that needs to be addressed, and you can see we're working on that on both sides of the house. In your view, should we broaden the scope and address the issue of seniors who could be victims of coercive control by their families, their own children sometimes? Is this something that we should look at, or is the couple relationship enough to cover the issue?
Thank you so much for this question. I strongly believe that seniors abuse elder abuse should be included, and it needs to be broadened. I think that the way that it's written right now is too narrow, and therefore it does leave out other vulnerable victims, such as elders, such as people who are sexually exploited, such as people who are being coerced through gangs. Child abuse, I think that there are a bunch of ways that it's not broad enough, and I think that and I feel like I'm flogging a dead horse here, but I think that if we change the language to the language of a relationship based on dependency and trust, it would then broaden it enough to be able to cover all of those pieces. And in consultation with our partner organizations that are elder abuse organizations, they also feel the same way around the language of dependency and trust.
Merci, Madame Silverstone. Madame Kim, est-ce que...
Thank you, Ms. Silverstone. Ms. Kim, I'd like your view on the same question.
I'm sorry, and the question is whether elder abuse should be included in coercive control provisions?
Oui, est-ce que vous m'entendez quand je pose... Vous avez la traduction?
Are you hearing the interpretation? Yes, so I was asking, in your view, the issue of coercive control, should the scope be broadened of the provisions to include not only couples but also seniors, vulnerable people?
I think that I will just say, as I said previously, we don't think that criminalizing coercive control will get to the heart of the matter or the root causes of coercive control. And so we have some concerns about the way it is framed at the moment, and that I think it's much more effective to provide supports for people who can leave relationships that they feel is coercive, and that comes to social supports and economic supports, and not necessarily through criminal law.
Mais je suis pas certain de bien.
I'm not sure I've fully understood the position of your organization. You believe there shouldn't be provisions to fight coercive control, is that correct?
Yes, we have concerns about creating this new offense, especially without creating safeguards for survivors of coercive control who might be at risk of being charged themselves. And we have seen this with mandatory charging for domestic violence policies, where sometimes when police arrive and they don't know what's going on, then we've seen increases of both parties being charged. And there's also some questions about how police might actually recognize all patterns of coercive control, which is very nuanced, and it captures a wide range of behaviors. And because of those concerns, that at this time we do not support criminalizing coercive control, but we do want to fight coercive control by providing supports that survivors desperately need. And one of the recommendations that our organizations had was creating a gender-based violence commissioner, for example, that would actually provide direct support to survivors and actually get to the cause of this before these behaviors happen.
Merci. Dites-moi.
Thank you. Tell me, does your organization have statistics or detailed information? And now I'm changing the topic completely, but the issue of the distribution of intimate images. I imagine this is an issue you have to deal with on an almost daily basis. Do you have detailed information or statistics on the scope of this? Is there an increase over the years? And the people who are targeted by this, do you have those details and information?
Thank you. And I don't have the numbers off the top of my head, but of course, the issue of Grok, which was the AI tool on Twitter, and the users weaponizing this tool to create many deepfakes, have generated a lot of news. And I think there have been some analyses done on how the majority of the deepfakes that were created by Grok were of women.
Je vous remercie, Madame Kim. Je m'excuse de vous
Thank you, Ms. Kim. I'm sorry to interrupt you. The time is limited. I'd like to ask the same question to Ms. Silverstone. Do you have statistics on this issue or information more specifically?
So I don't have statistics on the prevalence of deep fakes. All the information we have are narrative, and their narrative from the experiences of our clients. And we can definitely say that that is increasingly a tool that's being used to perpetrate coercive control, especially post-exit from relationships.
Thank you. Thank you, Mr. Fortin. All right, we'll move into the first minute round, starting with Mr. Bauer, and the clock starts now.
Thank you. First, I'd like to address Ms. Irons. Thank you so much for attending today and for your testimony. On behalf of all my colleagues, I want to express my sincerest condolences on the loss of your daughter. And I commend you for turning that tragedy into the advocacy work that you're doing today. And I hope that we can certainly benefit and pray that no parent has to go for that ever again. I want to begin by asking Ms. Kim, specifically with respect to one of the recommendations that she makes with respect to deepfakes. Our committee is often bogged down in politics and in big concepts, but I like to do some technical work. And if you think that the government has gotten a provision wrong here, then and you think it should be expanded, then I'd like to offer you the opportunity to do that. I was unable to locate that in your submissions. However, my understanding, Ms. Kim, is that you're suggesting that deepfakes should not necessarily just reflect a realistic depiction of the victim, but also capture what might be an unrealistic depiction. Is that correct?
Yes. So I believe the last part of the definition of deepfakes proposed in the bill states that it has to be likely to be mistaken for a visual recording of the person, and we think that this part creates too high of a threshold. That if something has to be as so realistic to be considered criminal, because if we've seen examples of harmful deepfakes in the Grok example where users asked Grok to put women in bikinis or, make them force smiles or cover them in blood. And all of those things are acts of harm, but they wouldn't necessarily be caught under this definition of a deepfake because they wouldn't necessarily be considered a realistic representation of them. But their images are still being taken without their consent and are being sexualized. And that is the act of harm.
So for the benefit of my colleagues, I think Ms. Kim is referring to Section 15, Sub 2, Sub B of the bill, and specifically the last part that suggests that if the person is depicted or exposed, and if the depiction is likely to be mistaken for a visual recording of that person. And I think the French version of the same section is fairly similar. I would actually go even further. I would suggest that you can have an unrealistic depiction of a person that may be used in a perverted fashion. For instance, one might have qualities that are not human qualities, and at the same time be depicted in a sexual fashion. So I agree with you 100%, Ms. Kim. How would you suggest that we fix it literally? Because you still have to refer to the identity of the person, of the victim here. And maybe you're not able to answer that question right now, but I certainly invite you to email my office with any technical suggestions. But if you have an answer now, that'd be great.
Sure. So our suggestion was simply to remove that last part where it says if the depiction is likely to be mistaken for a visual recording of that person, because the earlier part of the definition, it does require that it's an identifiable person who is depicted as nude or exposed to their sexual organs or engaged in explicit sexual activity. So our suggestion is simply just to remove that last part.
Okay. Ms. Irons, I note that women tend to be affected by sexual violence disproportionately. And it has been a long-standing position of the Conservative Party that when it comes to sentencing for sexual offenses, that such sentencing for multiple offenses should particularly be comprised out of consecutive sentencing rather than concurrent. So if you have two sexual offenses, then they would be consecutively served as opposed to sentenced concurrently. How do you feel about that? Ms. Irons?
Actually, my concern would be that I'd love to see that, except that my concern would be it would be constitutionally challenged. And I believe in the past there have been constitutional challenges to consecutive sentencing.
Thank you, Mr. Bauer. You're out of time. Mr. Chang, for 5 minutes.
Thank you, Mr. Chair. Ms. Irons, thank you so much for your courage. From your perspective, what are the key warning signs or system failure that, if addressed earlier, might have changed the outcome of your daughter?
Well, in fact, I've testified before on Bill C-71 on the fact that my daughter's killer, and it's not as necessarily relevant to this bill, but in fact, the other thing that he had hidden from my daughter was a criminal adult history of personal violence in which he'd been convicted of assault and forcible confinement. He hid his criminal record from her. He served 2 years probation because his parents helped him plea bargain out of those charges. Well, he didn't plea bargain out of them. He was found guilty, but he got 2 years probation and immediately applied for a gun license and got one. So I've had that investigated through other avenues, and that caused changes in Bill C-71 to the area of background checks for licensing in guns. In terms of the coercive control, Ms. Kim spoke about evidentiary requirements, but I can tell you that when England, Wales, and Scotland started down this road, there were very, very few cases in the first year. But by now, in 2024, there were 5,000 charges of coercive control laid. There were 853 convictions, and of those, 832 were men. So in my view, that tends to counter Ms. Kim's position a little bit of a disproportionate impact, for example, on Indigenous women. Mind you, in the data that I have on how it's faring in England and Wales, I didn't have any racial breakdown to access.
Thank you. And how would you believe Bill C-16 could better account for or respond to situations involving domestic violence, particularly those who may be at high risk but feel unable to seek help?
Well, as I said in my opening remarks, what I really strongly feel is if we can successfully educate the justice system as to what coercive control actually is, if we can then actually get some cases prosecuted, because that is another issue in Britain, and we can get some convictions, what you're then building is an evidentiary pattern, such that if it later results in further violence, or as in my daughter's case, femicide, there is an evidentiary record. And right now, that doesn't exist for women in situations like my daughter. In fact, former MP Pam Demoff said to me once, can you imagine, how could Lindsay have gone to court to get a red flag order based on this type of coercive control? That was a very high legal bar. My daughter would have never been given an emergency risk order. She wouldn't have been successful. So there was actually nothing in place. Because he never laid a hand on her, there was nothing about which my daughter could complain to the police. The only thing was his threats of suicide. And as I mentioned, she was terribly afraid that she would experience reprisal if she reported that to the police. And she honestly believed in the gaslighting that he would never harm her.
Thank you.
I do think if we have the ability to get these prosecutions and convictions under coercive control, we can see things start to change with consequences.
Thank you. And what changes, whether in law enforcement, social services, or community awareness, do you think are most urgently needed to protect others from experiencing what your family went through?
Well, one is the provision for protection orders that's in Bill C-21, that if a person becomes the subject of a protection order for violence or abuse of women, if they're a licensed gun owner, their gun license and their guns will be immediately forfeited or seized for the duration of the protection order, which could be as much as up to 2 years. But the other problem they're seeing in Britain is because the Crown is not prosecuting enough of these cases, then the number of police charges or efforts to have someone charged are somewhat declining. So I think the education of Crown Counsel and the judges is extremely important. In Britain, they were initially 50% were failing in court because the defense counsel and the judges believed that violence should be an element of a coercive control prosecution. And that's just simply not true.
Thank you, Mr. Cheng. So, time, Mr. Fortin, for 5 minutes.
Merci, Monsieur.
Thank you, Mr. Chair.
2 minutes et demie.
Challenge your decision. Okay. Madame,
Ms. Silverstone, I'd like to know, I understand that your position on criminal harassment, it wouldn't be subjective, it would be objective fear to see if the person reasonably could feel harassed. I think you had objections to that change. I'd like to hear you speak to that. How is it that changing the criteria from subjective to objective fear could harm victims?
So one of the things that we always say about coercive control is that fear is in the eye of the beholder. And so, for example, I could have my partner show up every single day at lunch at my work with flowers, and that's a lovely act for me. Someone else whose partner is coercively controlling, who does exactly the same thing, what they're actually doing is checking up on them and making sure that they're not having lunch with anyone they're not supposed to, that they're eating what they're supposed to be eating, and what exactly it is that they're doing. And so when we say that something is measured by an objective standard, we're giving all of the power to the perpetrator to define what those actions are, or the system to define what the actions are. What we need to have is a survivor impact framework where what we're looking at is the behaviors and the impact of those behaviors on the individual, because what we're seeing often is only the tip of the iceberg of a pattern of behavior that's being used to control somebody. And so that's why I also recommend that the evidentiary standards include the ability for expert testimony from witnesses around the impact on the victim, as well as other corollary information that can track things like that, like digital trails and that sort of thing.
Madame Silverstone.
Ms. Silverstone, my time is running out. I have 2 minutes, but I don't want to forget to ask you. Earlier, I asked a question about statistics or more detailed information on the distribution of intimate images. So you and Ms. Kim or Ms. Irons, if you have information or statistics or details on that, I'd really be interested in receiving them. So if you could send them, please, that would be appreciated. I suspect that my time... Well, otherwise, Ms. Kim, your view quickly on the issue we were talking about, the criteria of subjective or objective fear. Do you have a point of view on that?
Yes, and our position is to maintain the current wording of the criminal harassment offense, so not replace the subjective fear with an objective requirement, and our concern also rests with how objective fear might be assessed, and that might fail to account the power imbalances between the abuser and the survivor, and there could be some social and systemic biases that might influence what an objective fear looks like.
Thank you, Ms. Kim. I'm going to have to stop you there. Thank you. Thank you, Mr. Fortin. Okay, there's 2 more people left in this round, but we're going to cut into the second hour. I've got Ms. Cody next, and then Mr. Housefather, I believe. Are you okay if we go like 3 minutes each, and then we don't change the second hour too much? You're good with that? We'll deal with that separately, too. That's another reason why I want to move it along. Okay, so Ms. Cody, I'll give you 3 minutes, and then I believe it'll be Ms. Dillon, perhaps, or Ms. Nathan, okay? Ms. Cody, go ahead for 3 minutes.
This is to
I'm sorry, I can't hear you.
Through you, Chair. Thank you for the witnesses for coming today. I also want to give my condolences to Ms. Irons on the loss of her daughter. In my work on the Status of Women Committee, I've heard concerning testimony that the trafficking and exploitation of seniors is increasing. I've also heard through conversations with the Chief of Police of a northern community that elder abuse is now ranking third behind intimate partner violence and child exploitation. So my question is for Andrea Silverstone. From your experience in domestic violence prevention, are you seeing coercive control impacting seniors or older women differently, particularly through dependency, isolation, or financial control?
So the answer is absolutely yes, for all of the reasons that you said, and I'm going to add another layer, which is that in cases of elder abuse for really anyone, but in women in particular, sometimes the person who is the perpetrator is their child. And it is much more complex to untangle that relationship, especially when a parent feels a lot of responsibility for the behavior of their child, the relationship with their child, and can't separate themselves in the same way. And so therefore it adds another layer of complexity. And then of course we have additional vulnerabilities that seniors have just in terms of their capacity for their own caregiving, depending on where they are at in the journey of their lives. And so I think absolutely for the reasons that you said, as well as the additional ones.
Right. So do you feel that Bill C-16 gives enough tools to identify and respond to those situations?
Currently, as the bill is written, I don't think that it does. We've suggested this in our brief, but essentially what we're asking is that one of the sections that say for the purposes of this section, personally connected includes relationships of dependence and trust, whether or not the persons cohabitate or are related by blood or marriage.
Okay, I'd also like to ask Ms. Kim, from a legal perspective, do you see any gaps in Bill C-16 when it comes to protecting seniors, particularly in cases of coercion or financial abuse that may not fit traditional definitions of intimate partner violence?
I think certainly those gaps exist, but I'll just repeat that I think there needs to be supports for seniors that would actually allow them to get to a safer situation beyond criminal law reform.
To Ms. Silverstone, are there barriers that might make it harder for seniors to access these protections?
Well, I think right now, based as the piece of legislation has been written, it doesn't include seniors because it has to be an intimate partner relationship. So it only includes seniors that are in an intimate partner relationship, which is why the definition needs to be broadened, because we know that seniors are often in relationships of dependency and trust, sometimes with a caregiver that might be their child, sometimes with a caregiver that might be with their partner, which this legislation would cover, and sometimes with someone that's been hired. And in all of those cases, there's dependency and trust, and elders need to be considered and protected, and that is not currently broad enough under this piece of legislation.
Thank you, Ms. Silverstone. Thank you, Ms. Cody. Ms. Nathan, to you for 3 minutes.
Thank you, Mr. Chair. Through you, I want to thank all the witnesses, and especially Ms. Irons. I wanted to give you my condolences and commend your bravery. My first question is to Ms. Silverstone. SAGES has developed a reputation for working not just within survivors, but with the broader ecosystem around domestic violence prevention, including in schools, workplaces, community organizations. Your organization works extensively on behavior change programs for those who perpetrate domestic violence. How important is it that legislations like Bill C-16 is paired with intervention supports, not just for survivors, but for those at risk of causing them? And if you have any recommendations around that, you could give that now.
Well, thank you so much for this question, and thank you so much for looking at this issue as a broad issue. One of the things that we say at SAGES is that domestic abuse, coercive control is a whole society issue. There's the people that are harmed, the people who are using harm, and then the family and friends who are witnesses to it. And I think that the ecosystem that we take care of has to be the ecosystem of all of those people. And if we don't serve those who are harming, those who harm, and the informal supports, what we're going to do is actually not fully address this issue in the way that we need to. Ms. Kim has talked about how we need to have non-legislative responses. I absolutely agree, but I don't think they're mutually exclusive. I think we have to have legislative responses, and then we have to have really robust systemic responses for every part of society that's impacted by this issue. And I just also want to mention children are part of that as well.
Thank you for that. And I also know that your organization serves a diverse range of individuals across Alberta. And the experiences of coercive control can look very different depending on one's cultural background. immigration status or socioeconomic circumstances. In your experience working directly with communities, how important it is that legislation like Bill C-16 is implemented alongside culturally sensitive supports, and are there populations you believe this bill may have difficulty reaching?
So
And you
what
could
I'll
talk
say
a
is-
little bit about the First Nations as well if you want.
Sure. So what I'll say is this. We have an issue across Canada in that your zip code determines, or your postal code often will determine the level of service that you get. And that's not an issue with this piece of legislation, that's a Canada-wide issue. You know, we work across Alberta and Saskatchewan, and I would suggest that we see a very big difference in both the effectiveness of our programs as well as the response between urban and rural centers, just because there are less services available in rural centers. And I would also say that we see a difference when we work with Indigenous clients or clients from ethnocultural communities, also because of access to services, as well as access to justice, just based on geographic issues. I mean, if you don't have internet in the place that you live, or you don't have fresh running water, or somewhere, you know, to put your head at night, those are all massive issues. And so is this bill going to solve that? No. Do we still need to solve those problems? Yes. But I think that this bill, if, you know, paired with an understanding that we still need to be working on all of those issues, and also recognize that we need robust training and services to be able to create equity no matter what your postal code is. I think that
Thank you,
that's
Ms.
what we should be
Silverstone.
looking at.
Ms. Nason, thank you. Thank you to all three of you for coming today and participating in this important discussion about Bill C-16. So I'm going to have to, I'll suspend the meeting for just a moment or two. We've already have the next panel of witnesses queued up, so we don't have to stop for much time. So preferably stay in your seats, but I'll thank the witnesses again, and you can sign off now. We'll suspend for a moment.
Thank you so much for your time.
Thank you.
Thank you.
Meeting back to order. Thank you. We'll get going quickly here with our second panel of witnesses. From the Canadian Police Association, we have Tom Stamatakis, who's the president. From Humane Canada, we have Carrie Thompson, Manager, Justice and Legislative Affairs. And from RISE Women Legal Center, we have Vicky Law, Executive Director. You've all had your sound test completed. Thank you for coming. We're going to do opening comments followed by questions. So we'll give each of the witnesses up to 5 minutes for their opening statements. And after all three of you are completed, we'll get to questions. Ms. Law, you were nodding your head in agreement, so I'm going to start with you.
Thank you very much, Chair and committee members. My name is Vicky Law. I am a lawyer and the Executive Director of RISE Women's Legal Center. We deliver free family law services to women and gender diverse individuals in BC, specializing in supporting survivors of family violence. Our organization conducts original research into family violence and the legal system and provides ongoing training to law, social work students, and legal professionals across BC. With my limited time today, I want to focus my remarks on the potential criminalization of coercive and controlling behavior. My comments originate from RISE's joint written submission with West Coast Leaf Association, a BC-based legal advocacy organization working towards gender justice through litigation, law reform, and public legal education. Our submissions were provided to the Department of Justice in October of 2023. Before I dive into the criminal offense, I want to share that BC has included a definition of family violence in our family law legislation since 2013 that recognizes non-physical forms of violence, including coercion. We have also seen amendments to the Divorce Act in 2019 to include a new legal definition of family violence that specifically includes coercive and controlling behavior. So therefore, family law in BC has preceded criminal law in identifying controlling coercive behavior as unacceptable and harmful. Despite the expanded definition of family violence, which has been in place for over 10 years in BC, we continue to see courts, lawyers, and law enforcement struggle to meaningfully expand their view of coercive controlling behavior beyond a single incident-based physical violence. We continually see the minimization of non-physical violence. Survivors have shared that they have experienced death threats or threats causing bodily harm, which would attract a criminal response, but are often minimized as part of a breakup. We have heard many legal professionals hold the common but false belief that violence ends upon separation, and as a result, safety concerns are no longer present. In order to have effective laws to prevent further intimate partner violence, the creation of new criminal offenses and new legal definitions require difficult and systemic work to address pervasive misconceptions, myths, stereotypes, and biases. We encourage this government to adopt legislation that prohibits all forms of myth and stereotype reasoning. Dr. Kim Stanton, who recently completed a systemic review of BC's treatment of sexual and intimate partner violence in the legal system, recommends for the British Columbia government to consider the approach taken in Quebec's Bill 73 that explicitly lists 6 factors that are presumed irrelevant where allegations of sexual or spousal violence are present. We endorse this approach that these factors are important to consider and to adopt in legislation to prevent myth and stereotype reasoning. Coupled with false misconceptions, coercive control requires a radically different approach to understanding violence. It requires police and legal system professionals to recognize and assess subtle patterns occurring over long periods of time rather than focusing on individual incidents of assault. This shift requires ongoing and widespread education, including significant commitment to training legal system participants. I have heard Minister Fraser addressing the need to train law enforcement on the evolving use of technology to harm victims of violence, such as the use of electronic monitoring and deepfakes. It is our position that training on coercive control and the dynamics of intimate partner violence is equally important to fully comprehend the safety risk for survivors and their children. This recommendation is supported by Dr. Stanton, and while her report is focused on BC's legal system, I would encourage this committee to consider Dr. Stanton's recommendation when reviewing this bill and any other criminal offenses related to sexual or intimate partner violence. Dr. Stanton encouraged police officers to reframe their approach from what charges can be laid here to how can I keep them safe, a reference to the final report of the Mass Casualty Commission. History has shown us that we cannot create new laws without a wider investment in education and services. We have seen situations where a perpetrator is charged or even convicted with an offense related to intimate partner violence, and the perpetrator went on to commit femicides against previous intimate partners. This happened in the Renfrew County triple femicide of 2015, and earlier this year in BC, a woman was murdered, allegedly by her former partner, despite there being court orders related to domestic violence. And following recommendation 12 of the final report of the Mass Casualty Commission, we encourage the government to establish an expert advisory panel prior to finalizing any legislation relating to coercive
I'm going to have to
control.
ask you to stop there, Ms. Law. We're tight on time, so that's the 5 minutes.
Okay,
but there'll
can
be-
I just
I'll give you-
say that for a more fulsome discussion, please refer to our submissions that were provided to the Department of Justice in October of 2023. Thank you.
Thank you. Okay, Ms. Thompson, to you for up to 5 minutes.
Thank you, Mr. Chair. I appreciate that. Good afternoon, Mr. Chair, Vice Chairs, and committee members. Thank you for the opportunity to appear today. Humane Canada is the Federation of Humane Societies and SPCAs across 10 provinces and 2 territories. Our members are the organizations that Canadians rely on most to care for abused and abandoned animals, advocate for stronger protections, and support communities with resources and education. We are also the founders of the Canadian Violence Link Coalition, a partnership of multi-sector stakeholders examining the well-established connection between animal abuse and human violence, known as the Violence Link, which is often present in coercive control, intimate partner violence, and child sexual abuse. I'm here today to support Bill C-16 and its measures addressing animal sexual abuse images. These images are frequently used by predators to groom children and normalize sexual abuse. Animals are also used directly as tools of coercive control by abusers, and their abuse can signal escalation towards more severe forms of intimate partner violence. We are grateful to Minister Fraser for including these often forgotten victims in this bill. However, we must draw your attention to another emerging threat, animal cruelty and torture imagery. This content is being used by violent online networks to target and recruit vulnerable children and youth by desensitizing them towards extreme violence. Evidence from the RCMP and our own research indicates that nihilistic online groups like the CALM and 764 groom young people to build trust, then coerce them into creating and sharing increasingly severe content like animal torture, bestiality, child sexual exploitation, and self-harm. These networks operate in plain sight on platforms such as Telegram, Roblox, Discord, Minecraft, and Twitch, often luring targets to other platforms to continue grooming away from moderator oversight. There is also organized groups producing cruelty content such as crush videos for profit. The recent Winnipeg case where a couple created and sold animal crush videos to a Telegram group of over 100 members, which required applicants to provide video of themselves torturing an animal to gain membership, demonstrates that this violence is happening right here at home. While the Criminal Code addresses some forms of animal cruelty and sexual abuse, and Bill C-16 would criminalize the creation and distribution of bestiality representations, there is no meaningful mechanism to address non-sexual animal torture content and cruelty being created and circulated online. This material harms animals involved, as well as causes serious trauma to children, youth, and adults who may encounter it, whether intentionally or not. Worse, it can normalize violence and inspire viewers to act. In our submitted brief, we recommend strengthening Bill C-16 by criminalizing the creation, distribution, and possession of all animal cruelty and torture content, and by adding the creation and possession of animal sexual abuse imagery to the proposed offense under Section 163.1. These additions would help close existing loopholes and better reflect modern criminal harms. Recent media and research underscore the urgency of this issue. Just this past December, our government declared online nihilistic groups like 764, Maniac Murder Cult, and Terrorgram Collective as terrorist entities under the Criminal Code. These are the largest groups using child sexual abuse materials, CSAM, and animal torture imagery for maximum shock value and its ability to desensitize potential victims. The United States 2019 Preventing Animal Cruelty and Torture Act allows for prosecution of these offenses both within and outside their borders, something that Canada's current laws do not easily permit. A new report by Finland's Protect Children, sponsored by the UK online safety regulator Ofcom, involved over 20,000 adults who had viewed CSAM and found that nearly half of those respondents had also sought out or encountered other illegal content, most commonly animal cruelty, self-harm, and extreme violence. This intersection of violence is clear. Finally, laws are only as effective as their enforcement, so we urge that any amendments involving animal victims include mandated training for justice stakeholders on the nuances of animal abuse in relationship violence. Humane Canada would be happy to support the government with any research, training, and outreach to ensure that these measures are implemented effectively. Thank you, and I look forward to your questions.
Thank you, Ms. Thompson. Okay, over to you, Mr. Stamatakis.
Good evening, Mr. Chair and members of the committee. Thank you for the opportunity to appear before you today on behalf of the Canadian Police Association, representing more than 60,000 frontline police personnel in Canada. The CPA broadly supports Bill C-16, the Protecting Victims Act. From a frontline policing perspective, this legislation represents a meaningful and necessary step towards strengthening protections for victims, modernizing key elements of the criminal code, and addressing ongoing operational challenges within Canada's justice system. At its core, Bill C-16 reflects the realities that police officers encounter every day. The creation of a new offense targeting coercive or controlling behavior toward an intimate partner is an important recognition that violence is often a pattern of escalating conduct, not a single incident. Earlier intervention tools in these cases can help prevent more serious harm. The amendments to criminal harassment, moving from a subjective fear standard to an objective reasonableness test, will better align the law with how these offenses are investigated and practiced. We also support strengthened provisions related to child protection, including new offenses addressing the recruitment of youth into criminal activity and measures to combat online exploitation, which are areas of growing concern for our frontline officers. Mr. Chair, I would like to focus on what we see as one of the most important elements of this bill, the provisions addressing delay in the justice system. Since the Supreme Court's decision in Jordan, frontline police have seen the real consequences of delay in criminal proceedings. While intended to protect the rights of the accused, the operational reality is that serious cases are too often at risk of being stayed due to timelines that do not always reflect the complexity of modern investigations. Bill C-16 takes a constructive step forward by providing clearer guidance to the courts in assessing delay, including recognizing case complexity and reinforcing that a stay of proceedings should be a last resort. When serious cases are stayed due to delay, the impact is immediate and tangible. Victims are left without resolution, communities lose confidence in the system, and the work of frontline officers is undermined. These reforms help restore balance by ensuring that delay analysis better reflects the realities of contemporary policing, including digital evidence, multi-accused prosecutions, and the demands placed on victims and witnesses. Mr. Chair, I'd also like to briefly address some of the concerns that have been raised about this legislation. We have heard criticism that certain provisions go too far or reflect a particular ideological direction. From the perspective of frontline policing, we would suggest that this debate should remain grounded in practical realities. There is broad support across Canada for police and for holding offenders accountable, but that accountability depends on having a justice system that is equipped to respond to modern crime. Today's investigations are more complex, more digital, and often involve vulnerable victims. Measures that clarify offenses, modernize tools, and help ensure cases are not lost to delay are practical responses to those challenges, not ideological choices. Public safety policy is strongest when it's guided by evidence and operational experience. In our view, Bill C-16 largely reflects that approach. In closing, the Canadian Police Association supports Bill C-16 as an important and constructive step forward. It strengthens protections for victims, improves the ability of frontline officers to respond to evolving crime, and begins to address long-standing challenges related to delay in the justice system. We encourage all members of Parliament to focus on the practical impact of this legislation and the shared goal of maintaining a justice system that is both fair and effective. Thank you, and I look forward to your questions.
Thank you very much. Okay, we're going to start the first round. We're going to shorten it from 6 minutes to 5 minutes each in anticipation of the bells coming. Then we can get a full round in. Everybody's in agreement with that? Okay, Mr. Gill, I believe you're starting us off for 5 minutes.
So thank you, Chair, and thanks to all witnesses. My question to Mr. Stamatakis, do you believe that Bill C-16 is strong enough on criminals to protect victims?
Well, as I said in my remarks, I think it's a step in the right direction. I think it gives our members more tools in terms of how to respond to issues like coercive control, how to deal with the growing issue of the exploitation of children using technology to engage in those kinds of activities. So I think it's a step in the right direction. Can there be more? I think you can always come up with suggestions in terms of how to improve legislation.
So you just said it's a step in the right direction. Do you think we have to take more steps to make it robust?
Well, I heard some earlier testimony about including language in the legislation around protecting seniors who are often victims of whether it's coercive control or inappropriate conduct from family members or other people that they have relationships with. So that's just one example where there could be more added to the legislation. But like I said, I think this is a step in the right direction.
Do you believe that this bill does enough to deal with repeat offenders, particularly in intimate partner violences?
I think, you know, this is a conversation that's been happening in Canada for some time. There's a lot of consensus that we aren't appropriately dealing with repeat violent offenders. I think there's other legislation currently before the House, specifically with respect to bail reform, which I think is a step in the right direction as well. But again, I think anytime we can modernize legislation so that there are better, more effective tools for police to use, then yes, we will do a better job protecting people who are being victimized.
Okay. So you think that current bail provisions such as incomplete Bill C-14 on bail and sentencing undermines the intent of this bill?
No, that's not what I think at all.
So another question to you, Mr. Stamatek, is do you believe that law enforcement has sufficient resources to keep up with this proposed legislation?
I think resources in law enforcement generally in Canada are a challenge. I think they're a challenge. The challenge is different in different parts of the country. For example, in urban areas, we have more police officers, more access to a better response. You get into more rural, remote parts of the country where we're grossly understaffed in those parts of Canada, which again raises then challenge in terms of how you can respond to people who are being victimized. So I think in many ways, as I said before, when you modernize legislation, that creates efficiencies. I think if we can get into more proactive management of cases so that they're not being stayed or unnecessarily adjourned, all of those things together will provide better protection. And I think this bill takes us in the right direction.
Okay. I'll cede my time to Mr. Barber.
Thank you. Thank you, Chair. I wish to alert the committee for an article appearing this morning in the National Post titled, Fraser, that's Attorney General Fraser, says he considered the notwithstanding clause after the court struck down child support penalties. This is an article of this morning by Stephanie Taylor. I was pleased to learn that Sean Fraser had considered the invocation of the notwithstanding clause. However, I was reminded of his testimony from Monday, where he suggested that he did not feel that it was appropriate to invoke the notwithstanding clause in response to the Senneville and Nod decision that struck down the mandatory minimum sentences for child pornography, and specifically in Mr. Nod's case, that awarded him with 9 months instead of the mandatory 1 year subsequent to him found to be in possession of more than 250 videos of children being effectively raped. And I've put it to the Attorney General that this is precisely the type of scenario.
Mr. Barber, I'm going to have to stop you for two reasons. One, you're out of time. And two,
I have another 35 seconds.
You don't. And two, the bells are ringing.
This is not okay. On the clock here, we have 4 minutes
Mr.
and 35
Barber, we've had this
seconds.
discussion before. The clock is here. It's the same for everybody. You seem to be the only person who has a problem with it. You're out of time. The bells are ringing. We agreed we're going to finish this round. I need unanimous consent to adhere to that agreement, which we'll do 5 minutes each. We'll move to Mr. Chang and then Mr. Fortin, and then we can adjourn and go vote. Do I have unanimous consent? Yes, okay, thank you. Okay, Mr. Chang, you have 5 minutes.
Ms. Thompson, what legal protection currently exists or should exist to help survivors protect their pets or companion animals when living in an abusive relationship? And does Bill C-16 improve access to those protections?
Thank you for your question, MP Chang. The current bill as it stands does add provisions for animal victims as well as survivors of intimate partner violence. The challenge is the system is not there to support survivors with pets or animals, because there's only, I believe, 28% of gender-based violence, anti-violence shelters that accept animals in their shelters. So we welcome this bill for the provisions that it adds for animal victims of this type of violence, because they are very often used as pawns in that sort of abusers' tactics to terrorize their victims. So it's systemic supports that exist beyond the criminal element that we need to beef up on.
Thank you. And what changes, whether in law enforcement, social services, or community awareness, do you think most urgently needed to protect those who have animals or companion animals or pets?
I think that all three of them could use training on how animal abuse manifests in relationship violence. It's not always physical.
So if we could keep the chatter down in the room, please. It's hard to hear the witness. Thank you.
It's not always physical. There's emotional abuse with threats of the animal. There's financial abuse where you're not allowed to take the animal to the vet or to feed them. In some cases, there's also technologically facilitated abuse where trackers are put on leashes. So training on what constitutes animal abuse in that particular situation is desperately needed on all levels: law enforcement, community services, and justice stakeholders as well.
Thank you very much. And now we'll turn to Ms. Law. The bill proposed treating certain killings of women as first-degree murder under the concept of femicide. Do you believe this legal recognition will have practical effects on prevention or accountability?
Thank you, Mr. Chang. Our organization does not provide criminal law services, so unfortunately, I won't be able to speak to your question.
Okay. And then what about Bill C-16 introduces new offenses targeting coercive and controlling behavior in intimate relationships. From your experience, how important is this change for survivors who often face non-physical form of abuse?
In my experience and the organization, I think I want to echo Ms. Kim and Ms. Silverstone's comments from the earlier panel. There has been anti-violence experts that have identified the difficulties of survivors accessing this protection under the criminal code. We currently have other criminal code offenses that could protect survivors. We know that intimate partner violence, sexual assaults are one of the highest underreported crimes. And I don't think the creation of this coercive and controlling criminal offense will change that.
And how do you assess the potential of Bill C-16 to meaningfully improve the safety and access to justice for survivors of gender-based violence or intimate partner violence?
Yes, and as I said in my opening remarks, I think the best way to move forward to provide protection is echoing what Ms. Thompson said, which is education. Education for all legal system actors in understanding what intimate partner violence is, so that police officers, Crown prosecutors, judges can move forward and afford the necessary protection to survivors and victims.
Thank you. I have no further questions.
Thank you, Mr. Chang. Okay, over to you, Mr. Fortin, for the last 5-minute round.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Stamatakis, I'd like to know, from the point of view of police officers, we understand Bill C-16 proposes to fight violence between couples, coercive control. It's a scourge that we want to and need to fight. I'd like to have your view on the opportunity of applying this to the elderly. Is this a common phenomenon to have police called when there's coercive control with elderly people, whether by their children, neighbor, or other people close to them?
Yes, it's a very common occurrence. The police often get called to respond to, and it's challenging because I've heard witnesses give previous testimony around that in terms of, often it's a child or it's a caregiver. The senior person perhaps has some challenges in terms of communicating what's been happening. So it is a significant challenge. And I think if there was specific legislation around that specifically to the issue of seniors who are victimized this way, I think it would be helpful.
Est-ce que vous avez des statistiques, vous?
Do you have statistics, or the Canadian Police Association statistics, on how often you have to intervene in similar cases with elderly people?
I don't have statistics with me at the moment, but I can get you, we will have statistics about those types of calls, and I can get you that information.
Merci, ce serait très apprécié.
Thank you. That would be much appreciated. You can send it to the clerk that you were in touch with up till now. The clerk will send it to us. I have another question I wanted to raise with you. Mandatory minimum sentences. We know it's a debate that's come up a number of times over the past few years since I've been here. We've been talking about it for 10 years and probably even longer than that. So there's a desire for more mandatory minimum sentences, but others would say that it's not necessary or helpful, and the Supreme Court has struck many down. C-16 proposes to reinstate some mandatory minimum sentences, saying that the court could have exceptions if in the circumstances before it would be a cruel or unusual punishment. I'd like to have your view on that. First, mandatory minimum sentences, do they have a deterrent effect? Does it help your members do their work? And second, having exceptions in specific cases, is that a good thing in your view?
So I think mandatory minimum sentences are an important subject, and it has been the subject of much conversation. I've been involved in that conversation over many years while in this role. Look at sentencing people appropriately when they commit offenses is an important tool, both in terms of deterring those very people from recommitting offenses or deterring other people from committing those offenses. And at the very least, it does help us from a frontline policing perspective, because it takes that offender away from the community where they're causing harm and puts them into an institution for a period of time. The challenge is we need to build more capacity in our institutions, both in terms of housing people, but also in terms of how are we getting to the underlying issues? Because if all we do is sentence people to jail without getting to those underlying issues that drive the offenses, we're not going to get to better outcomes ultimately.
Merci, M. Stamatakis. Il y a également...
Thank you, Mr. Stamatakis. On the same topic of mandatory minimum sentences, there's a school of thought that says that it would especially affect marginalized communities. For example, the Black community or Indigenous people. I'd like to hear your view on this. Is it the case that there's cause for concern of the effect of mandatory minimum sentences on those specific communities, or is that a false problem?
I think it's a complex problem. I think it's a problem that requires a lot of context. And I think, again, you have to get to, instead of focusing on the outcomes, which can often be the arrests or the incarceration of somebody from a marginalized or vulnerable community, it's about how about looking at why those people are finding themselves in circumstances where they're having these interactions with the police. And we need to look at that more carefully and do more about that.
Je suis content de vous entendre, c'est ce que je pensais.
I am happy to hear you. That's what I thought. I would have liked to go further, but thank you.
All right, thank you, everybody. Thank you to our witnesses. I appreciate the time. Unfortunately, we were called away to go vote, but we got your evidence in, and we got one round of questioning, so we're very, very grateful. Thanks, everybody. Meeting adjourned.
Thank you.
Okay. Thank you.